Welcome to NACDL's Appellate Advocacy Series. My name is Bonnie Hoffman. I'm NACDL's Director of Public Defense Reform and Training. Today's program is supported by grant number 2013 MU-BXK014, awarded by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Office of Justice Programs, which also includes the Bureau of Justice Statistics, the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, the Office for Victims of Crime, and the Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking. Points of view or opinions expressed in this program are those of the presenters and do not necessarily represent the official positions or policies of the U.S. Department of Justice. This session, the Ethics and Practice of Appellate Attorney-Client Relationships, is one of a three-part series on appellate advocacy. The remaining two sessions, Procedure and Issue Identification and Persuasive Writing and Argument, will be available on our Ustream channel for later release. Today's speakers are Stephen Morrison, Assistant Professor at the University of North Dakota School of Law, an attorney at law representing individuals primarily in appellate matters; Catherine French Zagurskie, Chief Appellate Counsel for the Virginia Indigent Defense Commission; and Peter Goldberger, Founder and Principal of the Law Office of Peter Goldberger in Ardmore, Pennsylvania, specializing in post-conviction representation in federal cases, particularly appeals.
Thank you, Bonnie. Today we're going to talk about ethics and the practice of the appellate attorney-client relationship. And before we get really into our conversation, I know that everyone's from different jurisdictions. Some people are practicing federally, some people are practicing in state courts. So I want to talk briefly about the various guides that will assist you in terms of what's ethically appropriate in your jurisdiction, right? So in whichever jurisdiction you practice in, you're going to have a mandatory binding rule of ethics. And that's what you're going to need to know for your individual jurisdiction and abide by in order to keep your law license, right? Throughout this presentation, we're going to be referring to the American Bar Association's model rules. Many of the states have adopted the ABA model rules, so for a majority of attorneys, the ABA model rules are going to be exact or very similar to your mandatory state or jurisdictional rule of ethics. Also going to discuss various standards of practice. Some people in some different jurisdictions might have mandatory standards of practice. For example, in Virginia, if you're a court-appointed attorney, you have to follow the standards of practice, which there's a portion on appellate representation. So that becomes a mandatory guide for you when you're discussing or having an ethical dilemma or a concern. However, there's other standards of practice that are put out there, such as by the American Bar Association, which we're going to refer to in the materials, which are aspirational and they're not mandatory, but they're definitely a guide to walk you through different issues and questions you may have. Finally, as you'll see in the materials, we've cited to various cases, particularly United States Supreme Court cases, where they've kind of outlined the minimum standards in terms of what effective representation is to be. Okay. I'm going to start at the beginning, talk a little bit about the client's right to appeal. So, it is the client's right and decision to appeal. Doesn't matter if the client pled guilty, doesn't matter if the client pled not guilty and was found guilty. No matter what happens, that client has a fundamental right to appeal that decision. Now, it's your job as an advocate to make sure that they exercise that right in an informed manner. So you're going to need to consult with your client regarding exercising the right to appeal. And sometimes the advice might be not to appeal. For example, if the client received a revocation of a suspended sentence and there's really no issues and the client wants to appeal, your consultation might actually be discouraging of an appeal because you can give your candid advice ethically. Other times you might want to encourage your client to appeal and to explain why that is. So you must, under ethical rules, always consult with the client about their right to appeal. Let them know that they have that right. But you have to go beyond that. And the goal is to make sure that the client has an informed decision. So what does consulting with your client look like? Well, it's case specific, but you're also going to talk about the advantages and disadvantages of appealing. For example, the client needs to know that the appellate process can take a fair amount of time and that it moves slowly. So if a client only received a 6-month sentence, they need to understand that the appellate process could take up to 2 years or so, and that might factor in their decision. Have to understand that an appeal is not free. Even for indigent clients, there could be costs involved. Also want to make sure that the client understands what a win is. That a win doesn't necessarily mean that the conviction is going to be reversed and the indictment dismissed. That a win could be a retrial, and the outcome at that trial could be a sentence better or worse. There are certain issues which will result in dismissal and vacation of that conviction, but others you might only be looking at a retrial or even a new sentencing hearing.
Maybe we should mention up front that the nature of this right to appeal can vary from jurisdiction to jurisdiction, because the Supreme Court of the United States says there is no inherent 14th Amendment due process right to any direct appeal in a criminal case at all, yet every state and the federal government does guarantee a right of direct appeal in criminal cases one way or another. It's in some states' state constitutions that there's a right to a direct appeal. Otherwise, it's by statute, maybe even by rules of court where courts have the authority to make such rules. And because the nature of the right can differ, what it means to exercise that right and the rights you have in connection with exercising that right may vary depending on how much like a constitutional right it is.
Right. And it's also going to determine what the client is appealing from might limit the scope of that appeal. So while a client has a right to appeal from a guilty plea and a finding of guilt after entry of that plea, they still have a right to appeal, although certain grounds are going to be waived. And the client's going to have to understand that they're not going to be able to challenge the sufficiency of the evidence, for instance, but that they could challenge that their plea wasn't actually entered knowingly and voluntarily, or that there could be a sentencing issue. Or the recent United States Supreme Court of Class brings up the idea that you can look at whether the underlying conviction that the client has been charged with and convicted of is actually constitutional. But the client needs to understand that there's only going to be certain grounds for them to appeal. Anything else in terms of when you consult with the client, what you discuss?
Well, based on what you just said, the things you can appeal, not only you need to think about things that might be procedurally barred by a plea agreement or anything else, but also issues that your client might think are issues but aren't, and your client might have an idea of what you can do on appeal, which might differ vastly from what an appellate court actually does. Mm-hmm. And so you need to have that discussion with your client about, this thing happened that you didn't like, but that's not an issue, but here is an issue that your client might not have thought of, and you need to have that discussion.
Right, and it's also about setting realistic expectations for the client so that the client understands that an appeal isn't a new trial, that the court's going to give, for most issues, deference to what happened in the lower court. So it's frequently an uphill battle, and it can be hard to win on appeal. So you want to set that expectation up front. You don't want to be hopeless, but you want to be realistic.
And so often that initial consultation, I find, includes a really basic explanation of what the legal system means by an appeal, which almost always has to include some discussion of what is a record. That an appeal is based on a record that already exists, with very few exceptions probably, and what we mean by an appeal, and that it's going to be looking, the way I often try to explain it is, things that the judge or the prosecutor did wrong that might have affected how the case came out to your detriment. That's kind of the short explanation in plain English that I try to give and build on.
Right. For a lot of clients, they'll want to raise an issue such as that witness was lying on the stand, and you need to have that frank conversation to understand that in terms of who the judge believes that battle is best won in the trial court. So while that might be a focus that's really bothering the client, to help them understand that this legal issue that the client might not think is a big deal is actually the better issue that could effectuate that end result of what that client wants, which is the conviction overturned. And that as much as the client may be right that that witness lied, that the appellate courts are going to allow the judge to make that decision whether or not that witness was believable, right? Making terms of credibility decisions.
I was interested when you mentioned, Catherine, that there could be costs to taking an appeal even for an indigent defendant, and I'm not sure I understood what you meant by that. Did you mean literally financial costs, or do you mean personal costs and inconveniences that should be brought up as well?
Literally, there can be court costs that will be assessed to the clients. And that the case, that the more it advances or the more review that it gets, in a way, if they're going to give a meritorious review on the client's appeal, that can actually increase the costs. So that's something else to consider. You have a client who maybe has a life sentence, they're not going to care at all about the cost, but you have someone who wants to appeal a misdemeanor conviction. The weighing of costs might have an impact on their decision whether or not to appeal.
So do you think in this process of consulting with the client, that the conversation probably should also include the psychological, personal factor of, like, is it, if you think the appeal has a very small to nil chance of prevailing, that it might be better for you to wrap your head around that and get ready to accept that versus keep hope alive?
But I do think it's important for the client to have your candid assessment and a realistic appreciation, because even with the best appellate issues, it's still generally an uphill battle. And sometimes I'll even tell clients, I'll know my jurisdiction statistics that in the intermediate level court, there's about a 10% chance that your petition will even be reviewed on the merits. And when you go to the Supreme Court, it's maybe a 1 or 2% chance.
That's Virginia talk. What do you mean by that?
That even though you have a right to appeal in Virginia, you still have to go through a petition process in order to get in another door to have a review by a panel.
So there's a jurisdiction
merits.
where the so-called right to appeal is the right to file a notice of appeal, but not
Correct.
necessarily the right to have the merits of your appeal
Right.
heard by an appellate court without
Right.
proving a justification for it.
Right, so only
All right.
about 10% of cases get through that first door and reach a merit stage. So sometimes just putting it in general odds, and then I'll be able to comment, I think that yours is a particularly strong case, or this is going to be tough, but we can definitely give it our best. But the other thing that I think is important when we're considering consulting with the client and discussing the right to appeal is not only what to talk about during that consultation, but when to have that talk. I think that ideally, if you were trial counsel and you know that you're going to remain appellate counsel, even at the earlier stages, you can your right to appeal is going to impact maybe whether or not you testify, for example. Certainly you have strategic considerations in the trial court about whether or not to testify, but I know on appeal, the client's testimony, if they've lost, it can only serve in many cases to actually hurt the appellate issue. So you can discuss a little bit about the appellate process throughout the entire case, but when you're really talking about the appeal, is you don't want to have that conversation right after that client was found guilty, right? You want to wait until actually after sentencing, because a lot of times they just get kind of sucker punched with, you're found guilty, want to appeal. Well, let's wait and see what happens in sentencing. Let's focus our energy on putting forth the best sentencing hearing that we can, and to ask for a reasonable sentence in light, and let's hope then that you might get a favorable sentence. Let's put our energy there. I've also seen attorneys where after the sentencing hearing, what you don't want to do is follow your client right back and talk to them at that time and ask whether or not they want to appeal. because you have to consider the client's emotional state. And of course, the client, after just being sentenced, is going to say, yes, I want to appeal. I think it's important to give kind of a cool-off period and wait a little bit until you go back and tell the client that you'll come talk to them in a few days and discuss whether or not the client would like to appeal. Okay. So I think it's clear that the client has that right to appeal. And it's also clear that if a client instructs you to appeal, you must note that appeal. Okay, so regardless of whether or not you think that it has merit, it doesn't matter. If the client instructs you that they want to appeal, you have to start taking the steps to perfect that appeal, which includes filing the notice and going forth. We'll talk a little bit later about what to do when you think that the appeal doesn't have merit, but at the beginning stage, if your client wants to appeal, you need to take the steps and follow that instruction and note the appeal. Although the client has the right to appeal, it's the attorney that decides the issues and arguments. But it's important to be client-centered and to include the client in that conversation. And what does that mean to be client-centered when you're deciding issues for appeal? Well, I think what that means is that you want to give genuine consideration to the issues that are important to the client and that the client wants to raise. And you might have a client who wants to raise that credibility of the witness issue or another issue that you know is not going to be successful in the appellate court. But in those situations, what you want to do is to explain to the client why they're unlikely to be successful and to try to get them on board with the issues that you want to raise so that the client feels as if they're part of that team. And even if you're making the decision at the end of the day, to have them have buy-in and have a sense of agreement to why those issues are being raised. And sometimes if a client really pushes for a particular issue and it's might not be the best issue, but it's not the worst issue too, give serious consideration of maybe having that be my third issue. I might put it at the bottom of the issues, but if it means that much to the client, certainly take the client's wishes. And if it's an argument that has some kind of merit, also consider raising. In fact, the ABA standard says that you should diligently attempt to accommodate your client's wishes. And if there's a colorable issue that your client wants to raise, that you should work with the client in having an acceptable resolution.
You know, something I've found quite useful, if only to make my life easier in dealing with my clients and to make them more comfortable, is I take the issues that my client thinks are issues, and I'll do the research, and if they're viable, I'll argue them. But if they're not viable, I will put the argument in a letter to my client explaining with case citations why that issue isn't reliable. In the first instance, the client sees that I've actually done the work, and I'm not just rejecting what he or she says. And then oftentimes they'll give that letter to a jailhouse attorney, and that attorney will look at the letter and be convinced. And that gets the client on my side, which only makes the whole process easier.
And related to that, what the client thinks is an issue may be completely wrong and not an issue, but if you may be able to think behind what the client's suggesting and have an idea of an issue that conveys that thought or that sentiment about what was wrong, what was unfair, in a different and more lawyerly way that will make the client happier.
And I've had clients raise issues to me that turned out to be the core and very meritorious issue in the case. So even if they're wrong 95% of the time, clients sometimes know more than you do in some circumstances, so it pays to listen to them.
Right, and it certainly develops your relationship, and what you're saying, it's very respectful to the client to explain in a letter why you're making a particular decision if it is at odds with what the client wants to raise on appeal. The other person to discuss in terms of what issues to raise besides the client is if you are not trial counsel, you want to talk with trial counsel and get their perspective regarding the issues. In some cases, a trial attorney and the appellate attorney might look at the case, and they do have different lens. They do have different ways of deciding what issues might be viable. But it's good to get the trial attorney's perspective, because you might not have thought that that was as important an issue that maybe it was. So you want to have that conversation with the trial counsel in order to get different perspectives again. So what do you do when your client exercises his or her right to appeal and you think that there's nothing to appeal? There's no merit in any of the issues. You have to do something. You simply cannot ignore it or say. Some attorneys I've heard refer to ethics rules and say, I'm not allowed to file a meritless pleading. That's not true when it comes to appeals. Again, if your client has that right and instructs you to file an appeal, you have to file that notice and perfect that appeal. The way to think about
in the world of direct appeals in criminal cases.
Yes. The way to think about it, too, is you are an advocate. You can't make the legal determination that your client's appeal is without merit. Only the appellate court can make that finding. So keep that in the forefront of your mind, that your job is an advocate. So even if you think that it's non-meritorious, you can't conclude that it is non-meritorious. Only the appellate courts can. But if you believe that a client's appeal is non-meritorious, there's two different ways to approach it. One is to talk with your client, advise your client about why an appeal is not a good idea, and to counsel about withdrawing that appeal, to talk about some of the costs, to talk about the risks. And if maybe the client made that decision because they were in an emotional state of mind, and now they've had some time to reflect on it. But you can talk and advise your client not to appeal. The client is on board to assist them with any withdrawal of that appeal.
I think that may be even more pertinent with private appeals, but it's not exclusive to private appeals. So in my practice, which is 85 or 90% private and 10 or 15% appointed in my criminal appeals, the privately retained client, there are things you can talk about if it turns out to be a non-merit, in your considered judgment, a non-meritorious case, about withdrawing the appeal, because they have a significant financial incentive not to pursue the appeal. You probably have not earned your entire flat fee by the time you reach that point in the process. And the client may be more readily on board to join you or in signing, and probably will require the client's personal signature, a withdrawal of the direct appeal. But I'm interested in your perspective as a public defender. You're saying that can happen in a public defender practice as well.
Yes, that's certainly one path to take, is to start there and advise the client. But what's also important is to make sure the client understands the irrevocable nature of withdrawing the appeal, and that once they withdraw it, they can't change their mind again. But I've had situations where the client has received not a very long sentence, they've initiated the appeal, they're then released from incarceration, and they want to withdraw. And I'll have a talk with them about, well, just because you're released, you still might be on supervised probation, there's still consequences of a conviction. And again, sometimes I actually find myself talking a client into keeping an appeal. But if a client does want to withdraw, make sure that they understand the irrevocable nature, then to assist them in doing it. Because most jurisdictions do require the client's signature and affidavit, because it is a right that you're foregoing and you've already initiated.
I've actually drafted a statement for my clients to sign in that situation, which goes further than what's required by the court, because I thought what the court was requiring, the court that I practice in most often, the Third Circuit, was requiring people to sign, did not fully explain the irrevocable nature of the decision. So I took their form and I added a line that says, and I understand that if I withdraw this appeal, I will probably never be able to challenge my conviction and sentence again.
And I think that discussion I think that discussion's different, as we were indicating, whether you're talking with somebody who's a paying client versus somebody who's court-appointed, right? Somebody who's court-appointed, they basically might as well go ahead with the appeal, even if the likelihood of winning is virtually zero. Whereas somebody who's paying, you might be able to persuade them that, theoretically we could win, but we probably won't, and is it worth however much you might charge? So that conversation, I think, would go differently depending on the money involved.
Oh, I also think it's based on the unique circumstances of a case, because you might have a court-appointed client who your initial advice was not to appeal because you know that the issue would result in a retrial. Mm-hmm. And maybe you had a substitute judge that day, and you're afraid that for sentencing, if there was a retrial, that it would be harsher than the original sentence. So I think that there are reasons where a client who is indigent still may want to withdraw an appeal if it's an appeal that they really shouldn't have pursued in the first place.
Yeah, that's tricky because the client's protected against an increase in sentence after retrial if it appears to be retaliatory, but not if there's a legitimate independent basis for it.
So it really is a case-by-case situation. I think when we're talking about non-meritorious appeals, most of the time it's the second path that's followed. And the second path is the Anders procedure, or states generally have an equivalent. Anders procedure, first you need to explain to the client that you don't believe that the appeal has any merit, and if the client still wishes to pursue their right to appeal, the Anders procedure is that counsel files a motion to withdraw with the court, but in addition to filing that motion to withdraw, will also file a petition for appeal or a brief or whatever that pleading initially would be, which puts forth whatever the best issue there can be. And for all intents and purposes, it's the same thing that would be filed in a non-Anders situation. So you can't file the pleading or the brief or the petition and say, here's all the reasons why I think that it's without merit. You actually have to do the opposite. You actually have to try to find the most viable issue and raise it. So the Anders procedure is you file a motion to withdraw as counsel, you still file that brief or that petition, and then finally you need to file a motion for an extension of time so that if the court does relieve you, the client can file some supplemental briefs or petitions, because then the client is essentially going to be pro se at that point so that they can add to the issues. So the Anders process is actually harder than sometimes just doing a petition or a brief. But that's the procedure that if counsel believes that it's without merit. Now, my experience is that I personally think that Anders is overused. I think that the standard, looking at the court's language in Anders, is that the appeal has to be wholly frivolous. And I like to think that I'm a creative person and that I can find some issue to raise. I've never personally filed an Anders brief or petition, and that's not to say that that's wrong. I think different attorneys have different comfort levels, but I do confidently feel that it's overused. I do think that if you go to trial and the client pleads not guilty and is found guilty, there should be some issue. I think that if Anders is used, it might be more appropriate where there is, maybe it's a probation violation or an appeal from a guilty plea where the sentence was below the guidelines and there is no procedural issue. But I think for the most part, attorneys can be creative, and you can always ask for a change in the existing law, for a modification or a reversal. The other thing to keep in mind is that you can always hold the government accountable for proving the case. So they always have to meet that standard of proof. And so on appeal, I think that you can comfortably raise a sufficiency issue and argue that the evidence was not sufficient to prove the verdict. So I think that there's always something to find, to be creative, so as not to overuse Anders. And I'd be interested in your thoughts as
I've
practitioners?
I filed a handful of Anders briefs, and I'm comfortable that I didn't see any non-frivolous issues. I think probably all of those were coming out of a guilty plea. You're right. If there's a trial for which there was a guilty verdict, I think you're always, maybe not always, but you're almost always going to find some meritorious issue. I was actually inching towards filing an Anders brief in a probation violation case, but then upon consultation with my client, I saw some sort of issue. Probably will lose, but at least I could legitimately make the argument before the appellate court.
Yeah, and I've been going on 40 years as an appellate lawyer, and hundreds of cases I have literally never filed an Anders or Anders similar brief. I have had those conversations, though, half a dozen times with clients about withdrawing the notice of appeal or dismissing the appeal voluntarily, and had the client not agreed with me about that, I might have found myself in that situation. It's in the federal system where I mostly practice, even about there's enough complication in the sentencing process that you could almost certainly have something to say about a federal sentencing in almost any case, I would think.
I wonder if the fact that most of your clients are paid clients provides a screening function before you even get to the Anders decision.
I don't find that having more money correlates with having more good judgment. Not really. Not necessarily. Not about your own troubles.
The other thing when we're thinking about ethics and filing Anders is that I do think that there are certain circumstances where even if it might be appropriate to file an Anders, that it's not a good idea. So, for example, you might have a client where English is not their first language, and you know that if an Anders, if you're withdrawn, the client's going to be in a position where they're going to have to basically represent themselves. Well, that can create a whole slew of issues where you're really having the client be put at a disadvantage based on their language, when in the scheme of it, you're actually causing more harm to your client, and it might be better to stay in. I also had a situation where Virginia has the fugitive disentitlement document, where if the Commonwealth, and feel comfortable because they have to prove that the doctrine should apply, that if a client has essentially absconded from probation or is unknown of their whereabouts, that they might be waiving their right to appeal. Well, in that case, I wouldn't want to file an Anders because you're going to need to put your client's whereabouts, and if you don't know that and you don't want to tip off the government as to this. So I think that there's rare circumstances, but even if you think that the appeal is without merit and that Anders can be filed, is to see if there's other circumstances, other kind of ethical issues that might weigh in that. Now, the flip side, I have heard some practitioners, to be fair, say under their state or jurisdictional rules that the way that Anders is outlined, that if the attorney believes that the appeal is without merit, they have no choice but to file Anders. But again, what is without merit? We're defense attorneys. In terms of whether or not we know which version of the client's testimony is the truth or not, I think what's meritorious or not, there's some conscientious consideration that you can engage with ethically and still pursue.
One note, Catherine, you noted that when you file an Anders brief, you have to file a motion to continue to give your client time to file a pro se brief. In the Eighth Circuit, you don't have to do that. There's the presumption that the deadline is stayed. The court is going to take months.
I was going to say
Anders
that.
brief.
I think in many jurisdictions that extension of time and invitation to file a supplemental pro se brief is automatic. That goes once the Anders procedure is invoked.
And I think in the Eighth Circuit, I haven't seen an Anders brief that wasn't affirmed by the Eighth Circuit, but I think in the Eighth Circuit, if the court does find a meritorious issue, they won't have the appellant go pro se. They'll order the attorney to brief an issue. I think that's how it works.
I've seen it where if they don't allow counsel, if they find that there is essentially a meritorious issue, they'll withdraw that counsel who moved who made the Anders motion, but they'll appoint new counsel to the case. That's what I've seen happen.
Well, there's
too.
another disincentive to filing an Anders brief, because I have to say I have seen, if not once a year, it's certainly once every 2 years in one or another of the courts where I practice, a written opinion denying the Anders motion, sometimes naming the lawyer who filed it, and identifying the meritorious issue and reversing. And that's about as high up on the embarrassing list as you can get.
If you're gonna file an Anders brief, you want to make sure that doesn't happen.
Yes. Virginia actually had a case like that very recently, too, where they withdrew counsel, gave it to a law student, probation violation, and the law student successfully overturned that probation violation on a due process confrontation issue, and the client got a new hearing.
Sure.
And it was a published opinion. So that just goes to the idea that I do think Anders is
Yes. Overused.
overused. So if you are thinking about that path, really give conscientious consideration of whether you should do it or not. In terms of self-representation, I think you might be surprised to learn, or at least I was surprised, that there is no constitutional right to self-representation on a direct appeal from a criminal conviction. And why Ferretta, which gives the right to self-representation at trial, is a trial right. It doesn't apply to appeal, so that a client does not have a right to self-representation on appeal. Now, courts in their discretion may allow appellant to proceed pro se, but I've also seen courts appoint standby counsel for an appeal, where that can kind of get tricky in terms of the communication. So I think courts are hesitant to do that. So know that a client might be stuck with an attorney even if they want to represent themselves.
Well, just to be really exactly clear about what we're saying, the U.S. Supreme Court in the Martinez case said there's no federal constitutional right to represent yourself, but this is one of those situations where a state might recognize a right under the state constitution that's more indulgent of the individual than the federal constitution. And so a given state may say that the defendant appellant does have a right to represent himself or herself on appeal.
And I think there are some jurisdictions out there,
And that's
not many,
Sorry.
don't know, who allow a hybrid representation, where in a lot of jurisdictions, if the client's represented, they'll only accept pleadings from the attorney, but some courts will accept motions or other pro se filings.
Some courts forbid that, some courts allow it. And I was going to say that even where there is no right of self-representation, just to underline the point, which I think you did already mention, that the court may, in its discretion, allow someone to represent themselves, even though they have no right to. The court may have discretion to allow it. We even saw in the Third Circuit, the Federal Court of Appeals for the Third Circuit 2 years ago, a pro se appellant who was granted a writ ad testificandum and presented oral argument pro se before the Third Circuit, because that was a first in a career that I'd never seen that before. But they decided this guy, in this case, they wanted to allow it, and they did.
I think a lot of the important takeaway here is dealing with your client in terms of communication. Some clients might want to proceed pro se, and you have to figure out a way to tell them that you actually don't have that right, and that I'm your attorney. I'm sorry for that. I'll do the best I can, and I'll share with you why I'm doing the best possible. And then they might nevertheless file documents with the court, and the courts might consider them. They might not. I know the Eighth Circuit won't, and in fact, in one case, I had the court call me up and say, but not say in a nice way, that your client shouldn't file these things. And I told my client that the court's not going to listen to it, so maybe you don't want to bother filing them, but I'm not going to tell you not to. If you feel like you need to, please feel free to keep filing these things. So it comes down to communication with your client in many ways.
That's the perfect segue to our next subtopic, just communicating generally with the client. So taking a step back, the method of communication is really going to vary based on what it is, the content that you're communicating. We talked previously in one of the other parts of, at the beginning of the appeal, how it's ideal to have that in-person conversation with the client. But as the appeal moves on, a lot of the communication most likely is going to be through sending letters to the client, maybe a phone call here and there. But even if you're in the process of writing to a client, there might be an issue, or maybe the court there's a procedural hiccup, or there's something that really can't be explained in writing that you really need to pick up the phone or try to arrange a visit, even though it's further down in the appellate process. So different ways to communicate a lot of times will be in-person, phone, letter, but sometimes, understand the federal system, there's an email system that can be available to talk with counsel, or you might be communicating through a client's family or friend, even having a designated person that they might receive information.
In terms of written communication, let me just say that I have an absolute rule that I will send a copy to the client at the prison, marked attorney-client mail,
Yes, I do that too.
of everything I file on their behalf in the court, even if it's stupid, even if it's routine, just to show this case is moving and I'm working for you and I'm paying attention. Even if don't have time to write a letter to go with it, we'll attach just with a paper clip a little memo slip saying, here is what I filed for you in your appeal today. I like to have the word today in there if it's true, to say we are keeping you currently informed and look, we are working on your behalf.
That's an excellent point, is to remember that confidentiality too, that
Right.
if your client is incarcerated, to safeguard.
So in that connection, the federal, I think most people who have clients in federal prison would know this, but let me mention that the federal email system for prisoners is not confidential. We've been fighting that through NACDL and other groups for a while. We haven't won that they could establish a confidential module within that system, but they haven't. So it's a wonderful system, and not every prisoner is eligible for it, but those who have it, it's a wonderful way to say, I filed your brief today and a copy is coming in the mail. It's not an excellent method for saying, let me explain why I included this issue and didn't include that issue.
Peter, would you send to a client a routine motion to extend time to file your brief?
Absolutely. Absolutely. And I would find some way to explain to clients that the reason we are getting extensions of time, which I do a lot, is not because I have so many things better to do than work for my clients, but because it takes a long time to do your best work. And I'm working hard for him and for my other clients.
When you're communicating with your client too, it's important to understand your client, to make sure that they're going to be understanding what it is that you have to say. So you don't want to use legalese, you want to break it down and use plain English. And you also want to take into account things such as your client's educational background, or if they have a hearing disability or a visual disability, or if they're a juvenile, or if they're elderly. I had a client before who had vision problems, and he could read, but I had to use a very large size font. So I made sure
Yeah.
to do that. He was just older, and his eyesight was going, so I just had to make a note to remember to do that. But it's important to realize when you're writing, especially letters, what you will do a lot in appellate representation, is that you're not just writing a letter, you're actually communicating with your client, and it needs to sound conversational.
Right. I would say my presumption, unless I know differently about a given client, is I try to write at a 10th grade education level, which might be too high or might be too low, but that's my starting point, and I double space because I think that people who are not lawyers or other professionals find that less intimidating to read.
And writing a letter takes time. It takes half an hour maybe, and you might think that you don't have the time to do so, but if you communicate with your client adequately, if you gain their trust and you're able to have that good relationship, it will save you hours down the line.
Right.
So it's a smart investment of your time up front.
And some of the letters can almost be form letters because you're going to want to communicate and keep your client informed throughout the entire process. So every pleading that you file, every pleading that the government files, every order or opinion that comes back from an appellate court, you're going to be sending that to the client. So you can have certain form letters explaining this is where we are in the procedure. Enclosed you will find this document, because it's not case specific. You're just updating where the client is, where they are in the process, and attaching whatever pleading is going along with that particular process.
I'll have to admit, I don't
letters.
always send a government motion for extension of time, but I might, if I can, send an email on the system that says the prosecutor asked for and the court granted an extension of time. I did not agree to it, but this is something that they can do, and there was no point in opposing it. The court is going to grant it.
But certainly you would give them a copy of the Appellee's brief.
And they get a copy of the government's
Right.
brief. Although sometimes I don't send a copy of the government's brief until I have filed my reply. It's too upsetting. Until they see we have an answer for all those horrible things they're saying.
Some of the letters you're going to be initiating, right? But some you're also going to be receiving when the client writes to you. Just keep in mind, ethically, under most state ethic rules, that you have to promptly comply with a response to the client's questions, as long as it's a reasonable request that you haven't already addressed, or that how many times the client has answered it. But you do want to communicate and respond to client letters. Okay. Sometimes you will, for those important decisions, you may talk to your client over the phone. For instance, if there was an intermediary court decision that may be reversed in part, affirmed in part, and you want to talk to your client about next steps, that's going to be very hard to do in a letter, where most likely you're going to need a conversation with the client. And I think that anytime that you have substantive oral communication with the client, it's a good idea to follow it up with a letter confirming that you're understanding what the client's decision was. Similarly, I've had clients write me a letter. There's one instance where it seemed like the client didn't want to go from the intermediary court to the highest level court. And if I would have just stopped at the letter, I would have thought that the client didn't want to appeal. But by following up with that phone conversation, even though the letter sounded a lot like that they didn't want to further their appeal, at the end of the day, they did. So any kind of major decision that is changing the course of representation in any significant way, I think it's good to talk, I think to kind of follow up and confirm in writing. Another aspect that you're going to communicate with your client with is what your jurisdiction's practice regarding oral argument. So if the client is on bond and not incarcerated, that to inform them that they can come, maybe you want to talk to the client about whether it's a good idea for them to come or not. For a lot of appellate clients are incarcerated, and I know in our jurisdiction, the client will not be transported for oral argument. And it's important that the client understand that. But I'll remind the client that if they have a family member or a friend who wants to attend, that they're certainly more than welcome, and that there are recordings of oral argument that would ultimately be available to
Sometimes
them.
you can purchase or even get without purchasing a copy of that recording and transmit it to the prison where they may have, you have to probably get permission from the counselor to make sure you're doing this correctly, where the client would be able to hear the oral argument. In some jurisdictions and some prisons might allow that. I really like having clients' family come to oral argument, and the reason is appellate courts are very impressive. And they have often felt, most clients feel like they have not been treated fairly in the trial court. They weren't well listened to. I mean, sometimes they may have had a wonderful judge and a bad outcome, and they felt that the judge was very fair and listened to everybody. But that's the minority of cases. Whereas I don't think I've ever had a client family not be positively impressed with the seriousness and attention that judges are paying or appear to be paying at oral argument of an appeal. They may not feel that way after reading the opinion, but it actually enhances respect for the process and for the courts.
I think it's a good reminder for the courts that your client, even though your client might not physically be present, to remind about the humanity of your client. Sometimes I've said at the beginning
Yes.
of the argument, I'm representing this particular client whose family is
Sitting
right
in the
here.
second row there.
And
Yeah.
kind of remind them, and I wonder, to kind of curb what they have to say and to remember for them to be respectful, and that we're talking about a person and a
Sure.
person's liberty. Sometimes I think that judges could use that reminder. Finally, I think another area of communication that's important is when you have a decision from an intermediary appellate court, and you communicate that your client, that the conviction has been affirmed or the petition denied, or its unfavorable result in the intermediate appellate court, that they have a right to go further. And your scope of representation, you have to know that up front, and generally it's throughout the entire appellate process, both the intermediary court and the higher court for a direct appeal. And I've had situations where I've heard of attorneys writing something to a client saying, especially in a case where it's not Anders, but it's not the best issue, the Court of Appeals has unfavorably found this. I'm not going to appeal on your behalf unless if I hear from you that you wish to do so. That, I believe, is unethical. The presumption is that the client wants to appeal to both levels of court, unless if the client affirmatively tells you that he or she does not want to. So you can't place the burden on the client to tell you for certain that they want to go to the higher court. If anything, you phrase the communication as, unless I hear otherwise from you, I am planning to appeal to the state Supreme Court within so many days.
I would agree with that as an ethical matter. I think it's entirely possible that there are states where the state's own rules of practice say the opposite.
And in the federal rule, if you get an adverse ruling
Well,
from
it's a different situation.
an appellate court, there are a specific set of rules and guidelines that you have to follow when advising your client about filing a petition for cert in the U.S. Supreme Court, whether you're going to do it or not, and so forth. So if this is federal court, that be aware there are pretty specific rules out there.
And to know, again, the scope of representation of whether we're at the end of your representation versus if there's other future steps.
What would you say about a rehearing or reconsideration motion in the intermediate court? What do you think is the responsibility there, where a procedure like that exists?
I think where you have a halfway decent likelihood of prevailing.
But you don't. You never do. You have
That
an
then-
opportunity and a slim chance on that kind of procedure. I mean, wouldn't you say?
Generally speaking.
So do you feel like that's more the lawyer's call and less the client's right?
I think it's definitely the lawyer's call. If you have something of a chance, you might be ethically mandated to do so. But if the chance is truly slim to none, much like anything, you have to make the call that you think is best for your client.
Our standards of practice in Virginia is that you have to give conscientious consideration to filing any kind of petition for a hearing.
It sounds like a good standard.
Well, what do you do when you make a mistake during the appeal? Let's say you miss a deadline, or you didn't actually initiate the client's appeal, or the transcripts were filed too late. How do you protect your client's right to appeal when you're the one that makes the mistake? I think you begin first by telling your client that you made that mistake. And then do an examination of what's available in your jurisdiction to protect the client's right to appeal. So for example, if you catch the mistake rather quickly, maybe you can file a motion for an extension after the original deadline has passed to file that particular pleading. Or maybe you can file, or maybe you can just challenge that dismissal. Maybe the court was wrong and you're saying that the intermediary court should not have found a procedural violation. Virginia, we have something called a delayed appeal, which if you can ask the court with an affidavit from counsel that counsel has made an error, that the client is totally blameless, and to basically give the client a do-over because of your error. Other jurisdictions, you might need to go even further and assist your client in a habeas or other post-conviction relief, where you might need to withdraw as counsel, explain that you're ineffective, and recommend that they consult with another attorney. So you might be able to take some quick steps, some relatively easy steps to fix the mistake or your error, or you might really need to fall on your sword and do what you need to do to ensure that your client's right to appeal.
And situations like that can come up at later stages of the appeal as well. I mean, just to tell a horrible story that I experienced, I misjudged the willingness of an appellate court to grant an extension of time to file a reply brief. My experience told me they would give me this extension, and I acted, I took it for granted that they would, and then it was denied. And I filed a motion to reconsider that order, saying, please do not punish my innocent client, for my blameless client, for this situation. A reply brief would be helpful. If you feel that I was out of line in asking for this extension, find some way to blame me that doesn't hurt the client.
Right.
And unfortunately, they did. They reinstated the right to file a reply, and they penalized me. But it went against me and not against the client, and it was painful, but it was the right thing.
We're coming to near the end of our presentation, so it's a perfect time to talk about the end of appellate representation. So the first thing is you have to know the scope of your representation and when your representation actually ends, and hopefully you've already explained that to the client. Ultimately, ethically, that even if you're ending that representation, you have an ethical duty to protect the client's future interest. And so while your representation may have ended, you need to inform the client of future options that may be available to him or her. So that could include an appeal to the Supreme Court of the United States. That could be state habeas or other post-conviction proceedings. It could be a federal habeas, where you need to let them know of what future options that they have, along with any deadlines for those options, and to let them know that they might not have a right to counsel, although counsel might be appointed to them at a later state and time. So you want to be clear that your representation is ending, but to protect their future interests by letting them know what they might be able to pursue either on their own or with another attorney. And you might even take steps to make sure that your client is in a position to do so, making sure that they have a copy of his or her file. Maybe you file a motion to stay the mandate, or you file a petition for a hearing to kind of buy them some time to make a particular decision. Finally, what do you do if your client wins, right? And I think it also depends on what that win looks like.
I mean, whether you win.
Right. If the case gets remanded to lower court, you need to consider, okay, are you still going to be counsel? Or if you're not, to ensure that there's a seamless transition to new trial counsel. If it's reversed in part, do you take whatever win you have and be happy, or do you continue to fight? Does your client want to pursue what was affirmed or what was unfavorable? If your client is lucky to have complete reversal and a vacation of that conviction, the ultimate win, you want to make sure that you help your client get out as soon as possible. Sometimes the paperwork can take a while to get from the higher courts to the lower courts, so you might need to secure a bail or some other relief to get your client out from an incarcerating setting. And also know that if the client wins and it's an intermediate appellate court, that the government might actually appeal. And so while it's a win right now, the fight still, unfortunately, has to continue.
Great. In the time that we have left, there are just 2 questions that we hope we can cover before we're finished. One of them centers on the process of filing an appeal in the case of the client taking a plea. There are some jurisdictions, particularly for this questioner, where it seems as though the court requires there be a motion filed to vacate that plea before there can be, to withdraw the plea, before they can file the motion for, or the note for appeal. So if you have any guidance as to how the procedure would differ when you're dealing with a client who's taken a plea versus a client who has lost a trial.
That sounds like a state jurisdiction.
I would say, I think the first thing is that if your client does want to appeal a guilty plea, it is a good idea to consider whether there's time to do a motion to withdraw the guilty plea. So, for example, I know in Virginia, you only have 21 days after sentencing to withdraw the guilty plea or to file a motion to withdraw, but you have 30 days to file the notice of appeal. So I would suggest that the first thing you do is to look at those deadlines, because if your client tells you that he or she wants to appeal on day 23, the court might not any longer have jurisdiction over a motion to withdraw the guilty plea. But certainly if there's time, if the client has announced his or her decision to appeal, I do think that it's wise to consider withdrawing the guilty plea, because if that's denied, that'll give you another issue to appeal. So that is something that I think is worth talking to your client, but the deadlines can be different to file a notice of appeal and to file a motion to withdraw the guilty plea. So I would know your local jurisdictional timeline and deadline.
Right. Another thing to be careful of there is that you aren't confusing a line of cases in your jurisdiction that say that you can't prevail on appeal after a guilty plea if you did not preserve the issue by seeking to withdraw the plea in a timely way, versus are we saying there's a rule that literally says you can't even initiate an appeal if you haven't filed that motion?
And then much of what you guys have discussed centers on keeping the client informed. And so there is a question about what to give the client and how much to give the client and to whom you can give these documents. So in cases where the client is incarcerated and they've asked you to give the file to a family member, like if you have any thoughts about that, or dealing with the cost of making copies, or dealing with transcripts that you have been told not to copy, how to get those things to the clients, if it's fine to do it, if it's ethical to put them on PDFs or, not PDF, flash drives, because I know there's some technological ethical issues that accompany how you are maintaining confidentiality while you're transferring the information.
I, just as a general rule, wouldn't give records to family members or friends. I suppose if it's a public record, I could, but I deal with my clients. If they want any document, as long as there's no protective order, I'll copy the document and I'll send it to them. I have no problem with that.
You're presuming that the client has on board with providing this? The client's asking you to give the file to a family member? Or
typically, even when the client asks me to give something to a family member, I'll make an individual assessment as to whether that's appropriate. If it's a public document, I probably will. If it's work product or if it's something else that might violate attorney-client confidentiality, I almost certainly will not.
what if you think there's a danger to informants kind of issue where you suspect that you're being asked to give this record so that someone will have a basis to retaliate or harass a witness against the client?
I've never been put in that position, but if I thought there was a legitimate possibility that somebody would get harmed, I would not turn over the document.
So unfortunately, we're out of time, so I just want to thank our presenters for such an informative presentation and comprehensive discussion about the ethical obligations that attorneys face when dealing with appellate issues. And I also want to advise our viewers that we have 2 other parts of this appellate series that will be released shortly. The topics being procedure and issue identification, as well as persuasive writing and argument, and we'll be in contact with those who have registered and who have been demonstrating interest in this topic to let you know when you can find that material.
Well,
Thank you.